of UKBF Talks. Where have you been? We hope you've been checking out all our other content, but we're glad to have you here today. Today, I have the amazing, the superb, her dressing fits the couch. We have the lovely Sarah over this morning, and we're going to really chop it up about shareholders agreements this morning. So I'm going to go straight into it. Good morning, Sarah.
Good morning, Jacob.
How are you doing?
I'm good, thanks. It's great to be here.
It's great to have you. It's great to have you. I always ask this question to our guests, whether they're in person or whether it's online. Yeah. Have you had your breakfast this morning?
I have had my breakfast. I've had some porridge this morning.
What sort of porridge?
A bit of apple in there, some banana, raspberries, protein mix as well.
Okay.
So I'm set up for today.
Okay, that's good. And you've had your water as well?
I have had my water.
So you're living a very, very healthy lifestyle.
It seems so far.
That's good. That's good. That's good. So just to give them a bit of context to people watching, people listening, who are you and what do you do? So
Jacob, I'm a mediator.
Yes.
And that is basically helping people resolve disputes.
Okay.
I bring with that over 25 years as a dispute resolution solicitor. Okay. I struggled saying how many years that was then.
Wow. I'm not going to ask you how old you are.
Don't go down that route. But yeah, I mean, my life has been pretty much spent to looking at helping people in some form of conflict or other.
Wow. Wow. Before I actually go into my questions, what is the worst scenario you found yourself in as a mediator? But what's one of the most interesting scenarios you found yourself in as a mediator?
I think there is, my goodness, the most interesting, there are so many. Mm-hmm. But I think it's actually seeing people who are completely stuck when they come to see you and they go, I just can't see a way out of this. You know, I can't sleep, I can't eat. I want to spend time with my children, but this is all consuming. You know, I can't get this problem out of my head and I can't find a way forward. And it's been able to take that individual and bring them with a party that really they perhaps don't want even to look at and find a way forward for them. Yeah. So I don't know that it's interesting, but also for satisfying, it's actually being able to get people from that position of being stuck, looking backwards in their life when really they should be looking forwards. Yeah. You know, looking at all the enjoyment that they can have, and that's been stolen from them because actually they're all consumed in a dispute at that time, and been able to help them facilitate a way forward. So actually they can leave the past behind, they can leave the problems behind and begin to enjoy life again. Yeah. That for me is really important. Yeah.
For those that are watching and listening who may not know what a mediator does, can you explain that process and what the day-to-day of that looks like?
Yeah, of course. So from start, if somebody is in dispute and both parties want to find a way forward, then they can contact a mediator. Yeah. And the mediator then facilitates the communication between both parties, and that can be online, it could be in person. Generally it's over a course of a day, sometimes half a day, but usually a day. Yeah. And just begins to coach, negotiate, help people find that breakthrough. And quite often it's involving listening and getting over what somebody's position is and looking about what they really need. What is it that is really going to make that breakthrough to bring a solution? And it's often their best solution because sometimes the alternative is going to court. Yeah. And realistically, nobody wants to do that. Yes. It's costly, it's time consuming, it can be energy draining.
I can imagine.
And if you've got the option of being in one place, somebody to help you, to facilitate that conversation, to make a difference and to come out the other side just without the baggage.
Wow. And does a mediator specifically work in the business to business scenario, or can a mediator be in different scenarios as well?
Yeah, there are different types of mediators. Personally, I don't do family mediation,
Yeah.
but there's family mediation to help people in relationships. My focus is on business
Yeah.
and also workplace mediation.
Yeah.
So if people work together but perhaps don't have the great relationship, and that can impact upon everyone around them. So I could go into a company and begin to work with people with either a team or two individuals and help just get some understanding. There'll be some people who will never be great friends,
Yeah.
but they might be able, with some help, just to get that rapport that actually can bring the best out of both of them.
Yeah, yeah. No, that's good. That's good. I think it's good to lay the foundation of what mediation is, so that people watching and listening can understand. So, this conversation is about the importance of having a shareholders agreement.
Yeah.
Before we go into that, what is a shareholders agreement?
So, clue in the title. So a shareholders agreement is in essence a contract, and it's a contract between the shareholders in a business. Those are the owners, and it governs the relationship between those shareholders and also the management of the company. So that's its real purpose: relationship between the shareholders, the owners of the business, and the management of the company. It's not a document that's actually required by law. Doesn't need to be filed at Companies House, but there are benefits for shareholders that actually it's a good to have. It's good governance and actually can go a long way as a company develops.
Yeah, and when it comes to actually writing a shareholders agreement,
Yeah.
is it as simple as literally getting a piece of paper or getting a document, writing a few bullet points, a few do's, a few do nots? Is it that simple?
Probably not. Otherwise, I might not be here. But I think it's a good place to start.
Yes.
You know, so I mean, let's imagine we're setting up in business.
Yes.
And if you start that business journey,
Yeah.
your focus is quite often upon, you know, what are we going to do? What's our vision for this business? What are we going to sell? What are we going to market? Whom to? How is that going to work? But actually, behind all of that business progression, there's our relationship. You know, how are the people who own the business going to connect and work together?
Yes.
So when you've got that shareholder set up, what you want to do is think of that business journey and the relationship between the shareholders. And that tends to fall into three parts. You've got your startup, you know, the start of the relationship of the owners.
Yeah.
You follow on with the growth phase.
Yeah.
And I know you're doing a lot of talking about the growth phase in businesses. Yeah. And then finally, exit, whether that's selling the company at the end or one of the shareholders leaving.
Yeah.
So we'll start with a startup.
Let's go with startup.
Okay, so as shareholders in the business, we need to talk about what are we going to do? You know, what are each of our roles and how long are we going to spend doing that? Is this something we're going to jump into and work full time in? Or as the business builds, are we going to do this part-time whilst we've got income coming from somewhere else?
Yeah.
So that's going to be a really good place to start, a good conversation on what is our commitment to the business.
Yeah.
And how does that then link to how we get paid from the business? What dividends are we going to draw down? How frequently? You know, how will that look between us? And then, of course, if there's two of you in a business and you're making decisions, it might be that we don't always agree. So in that scenario, you get a deadlock. And what are we going to do about that? If I suddenly want to go and expand into America, and you're going, well, actually, we've not cracked the UK market yet. How are we going to resolve things like that? If I want to take out more finance, and you're saying, not yet, I'm not quite sure, what do we do? So your shareholders agreement, right at the start, covers all of those things.
Yeah.
And then from that startup point, you move into growth.
Yes.
So growth, really key for any business. You might bring more people into the business, may need more help, different expertise. What are we going to do as we want people to grow and develop? do we want to give people shares?
Yeah.
Do we want them to be part of what our journey is in business?
Yeah.
And in giving shares away, that's part of the ownership. So in actual fact, what does that look like? Are there going to be certain restrictions with those shares? So that if, for example, somebody says, well, actually, I've had a great time here, but my career is elsewhere, we may not want them to take their shares with them.
Yeah.
And suddenly they won't care about the business. So, you know, it might be that actually, if they leave the business, you want somebody to sell the shares back to the business or back to us as owners.
Yeah.
And unless that's included in the shareholders agreement, that can't happen.
Yeah.
So those types of things are conversations which we'd need to have and prepare for.
Yeah.
And in addition to that, with more people coming in, maybe shareholding, but there might be more directors as well.
Yeah.
And directors may or may not be shareholders. But actually under the Companies Act 2006, shareholders have duties to the company. And with those duties, there's decision making. And we might turn around and say, well, actually, we recognise that as directors, there's decision making, but we're the owners of the business, we founded it.
Yeah.
And actually, some of those decisions we want to keep for ourselves.
Yeah.
So in a shareholders agreement, you can actually specify what types of decisions you as majority shareholders would like to kind of have. So again, another really important thing to be able to specify and to set out right from the outset. And then that comes on to exit and leaving. You know, say things don't go so well for us in the business and one of us decides, well, actually, it's time to go. How does that look? Do we want to put in place some restrictive covenants so that you can't go down the road and then suddenly set up in business somewhere else that's close and take clients, etc.? Or what about confidentiality? There might be sort of business expertise that we've grown in, that knowledge. There may be issues on that front too.
Yeah.
So restrictions, confidentiality, but also you're in that scenario again where somebody could actually leave the business taking their shares with them. And as a founder, you may be very interested in what the value of those shares are.
Yeah.
So in a shareholders agreement, you can incorporate a valuation as well, how those shares will be valued, how they could be distributed on a right for first, if it's somebody to have the right to buy them back from you first, from that sort of scenario.
Yeah.
And all of that, again, so important just to set out right at the outset. The ultimate exit is if we're in a situation, if someone passes away. And what a lot of people don't realise is that if there isn't a shareholders agreement that stipulates that upon passing, that the shares come back to the business and the business can buy them or the shareholders can buy them, then those shares go into the estate of the person who's passed away. So you could find yourself in business with somebody you've never met.
Yeah.
It might be a spouse, a sibling, could be an Ida, whoever it might be, who actually doesn't know the business, doesn't bring the skills that actually you require, but actually all of a sudden has a lot of influence. And that is obviously a situation that both parties setting out probably want to protect against.
Wow. Gosh.
There's a lot to think about. A lot to think about.
Wow. Yeah, there's coming into this conversation, I kind of had a vague idea of why an agreement is needed, but as you kind of expanded on the different scenarios from especially the growth phase to the exit phase, especially the scenario if somebody was to leave the company or to pass away, what happens to shares? That's literally got me thinking now, like, what the heck? So that is, gosh, I've got a lot of questions to ask. So, how much does it cost to put together a shareholders agreement?
Yeah, well, like most things, you can find precedents on the web now.
Yeah.
So with a good Google search, you can come across those.
Good old Google.
Good old Google. However, instructing a professional advisor is always a good way to go as well. And there is a key reason for that too. So the cost, free, all the way through to getting professional advice.
Yeah.
Professional advice might run into 4 figures, a lower end of 4 figures.
Yeah.
And the reason for that is that when you have a shareholders agreement, you have to make sure that it sits with the constitution of the company. What I mean by the constitution of the company is that when the company is formed, it's formed and the company is issued with articles of association. That's part of the statutory required document that is lodged with Companies House at the very start, the very formation. And the Shareholders Agreement and the Articles of Association should complement each other.
Yep.
There is an overlap between them, so some of the content will be similar. But if you've got a situation where you've sat down, you've drafted your Shareholders Agreement, and you're saying, great, this is the document that this is what we want for our company,
Yep.
but then your articles don't reflect it, the articles will always come first because it's that statutory document.
Yeah.
So in that sort of situation, having somebody who can make sure that they both fit and align with each other to become a complete governance package for
Yeah.
the company is a sensible way to go.
Yeah. I want to ask and paint a particular scenario. If I'm somebody that is, let's say, setting up in real estate, I'm acquiring some houses, some properties, and I'm now looking to go into business with somebody, but the person doesn't really, I'm only bringing that person in for their finance, and not necessarily, I don't need their time, I don't need their skill, I just need investment. In that particular scenario, am I still permitted or advised to go down the route of having a shareholders agreement?
If you're going into that type of relationship, then actually there are other options for you. So unless you want them to have shares in your company,
Yeah.
then it might be something they're asking for, of course, but there are other ways of looking at it. It could be a joint venture. It could be something where you're actually paying for their services. You know, you might say, well, in this situation, I can see that I might need your support for X period of time, but after that, it might longer be necessary. So it really depends what you want out of that relationship. Certainly, if somebody is looking at investing in your company, or if they are, if you're going to a bank for funding, then you being able to say to them, I've got a shareholders document,
Yeah.
this is really part of our governance, we're taking our corporate governance seriously, that actually gives you additional credibility.
Okay.
So having those kinds of conversations are always a positive.
Yeah. Oh, wow. Okay. How long does the process take to piece together a shareholders agreement?
Again, depends how you want to do it. You could do it in an afternoon,
Yeah.
sitting down and if you're working together and looking at sort of these topics with your shareholders, with the shareholders as well, that's fine. If you seek professional advice, it might be a couple of weeks, 2 to 3 weeks.
Yeah.
Predominantly because you usually have to go through a know your client process first of all, so that all those sort of initial details, confirmation instructions and so forth are taken, and then someone will have a chat with you about what you want for your company.
Yeah.
And then that's translated, articles of association reviewed, and then you get the final documents to go through.
Okay.
And at that point, what I would say is some legal documents can be difficult to read. You have to make sure that you understand it, but it should be in plain English. You shouldn't receive something that makes no sense.
King James.
Exactly. And you know, it's got to be understood. It's
Yeah.
got to be something that's user friendly, that makes sense, that you can kind of go to and go, okay, there was something in this, and find it, read it, understand it.
Yeah. I guess my next, I think I know what you're going to already say. Being a mediator, do you need lawyers or solicitors involved in the process at any stage? Is it essential?
It's not perhaps essential. As I said, there are precedents out there that you can have a look through that can guide you through it.
Yeah.
Do I recommend it? Of course.
Yes.
That is really to give you some protection and also different insights and options as to how you can maybe resolve deadlock, for example. You know, what are the different scenarios and what are the options available to you when you start up and later on?
Yeah.
What different dispute resolution clauses can you include? All of those sorts of things. Someone who is used to dealing with these on a day-to-day basis will be able to give you those options.
Yeah. So at what stage in a business owner's journey should they consider using a shareholders agreement?
Ideally at the outset. That's when all the energy is there, it's positive, you're probably in agreement on most things with your other shareholders. So at that particular point in time, it is the best time really to get a shareholders agreement in place.
Yeah.
Doesn't prohibit being done much later in the day at all. I think when people sort of setting up in business though, you kind of get a little bit distracted along the way. And this, as I said, isn't a document that's required by law. So in some ways people might think, it's like a will, isn't it? We don't all have a will, but it's a good thing to have.
Yeah.
Shareholders agreement, really should have it for the reasons we've talked about, but it's not essential. You've got to build time in to actually commit to do it. So the further you get into a business, perhaps the less time you've got. Having it at the start to give you that really clear foundation and to build on the relationships between the shareholders, I'd always say right at the start.
Okay. And when can I break out of that? So if I am the business owner, I am somebody, I brought you to the table, I brought this person to the table, we've all got that agreement from the beginning. As a business owner, am I able to just click my fingers and it's done, or is there a process to that?
There's always a process to get out of something that's contractual.
Yeah.
So going back to the start, what a shareholders agreement is, it's a contract. And with any contract, whether it's with a service provider or so forth, there's always an exit clause in it too. So there will be a mechanism within that shareholders agreement for you to leave the business.
Yeah.
And actually that's quite helpful too, because it will set out the steps that are to be taken to do that in a good way.
Yeah.
That will be valuing the shares if you're not taking them with you, and what it looks like, timeframes, how that would work in practice. And all of that actually, it can just avoid really quite terse and tense conversations if there's a process and mechanism to follow. Yeah,
so we don't have to egg people's cars or pop people's tyres. We just
follow
the exit strategy that's dotted in the shareholders agreement. Yeah.
And I think at the start you've got to be realistic. Life is life. People change, priorities change. So actually having this conversation at the start, if this were to happen and I will want to leave, what would that look like?
Yeah.
How could we work so that actually the company and the business can still continue to run, but this is a good exit for us?
Yeah. No, that makes a lot of sense. So what are the advantages of having a shareholders agreement?
For me, the advantages would be clarity, credibility, and also certainty. Going back to if somebody has shares and they can leave the business and take the shares with them, that's not giving the certainty that you'd necessarily want for any company. You really want the people who are the shareholders to have a vested interest and really care what happens to the business. So certainly the advantages are it gives you a very, very clear indication as to what the shareholders are doing, what their roles are, how you'd expect them to behave and how committed they are.
Yeah.
But also it gives you that certainty. If somebody were to unfortunately pass away, that actually one of the relatives isn't going to come in with no knowledge, probably not much interest. You can keep the shares and actually retain that focus on what's in the company's best interests.
Yeah. Gosh. There's a film that just came to my head. This is so off topic, but it's have you heard of Richie Rich?
Yes.
Macaulay Culkin.
Yes.
So in Richie Rich, as we know the story of Richie Rich, for those that haven't watched it, or Macaulay Culkin's or Rich's parents, I think they're on a plane somewhere and their plane crashes, and they get stuck in a rubber dinghy in the middle of the ocean. And now Richie now becomes the head, a little kid becomes the head of $1 billion company. Would that have been a shareholders agreement? Would that have been in a shareholders agreement for for Richie to become the standing CEO of the company?
Well, it's a great one from a drama point of view. Now, in essence, there would be challenges because of his age.
Yeah.
So from that point of view, it's more likely to have a trust or something like that.
Yeah.
That would be involved.
Okay.
But that is the kind of scenario that,
Yeah.
that in actual fact, these off-the-wall things where somebody's not available,
Yeah.
what happens when? So yes, if the parents were to disappear and they're the major shareholders in the business, what happens with minority shareholders and how does that work?
Yeah.
And so it's a good scenario.
Good scenario.
Good scenario, yeah.
Oh, that's cool. So those were the advantages. Now, what are the disadvantages of having a shareholders agreement?
It's difficult to think of any disadvantages because actually all of the purpose behind the shareholders agreement is actually to help everybody and to give clarity. I think the disadvantages probably at the outset, time and cost. So those are a downside. Yeah. And also if you do get new shareholders coming in, but you don't actually get them to sign a shareholders agreement because you are only party to the shareholders agreement on signing it. So what you wouldn't want to have happen is to bring new shareholders in, not to include them in the shareholders agreement, not to get their buy-in, not to get them to sign, because then you're in a situation whereby some shareholders are part of it and some aren't. Yeah. So a disadvantage in that situation could be having it but not getting everyone to sign.
Yeah. So I thought that just came to me is like, so once again, I'm running my own company, you're a shareholder, that person's a shareholder, but then further down the line, we employ somebody, a director, who now is requesting shares in our company. But I know as a business owner that this person brings a lot of expertise that we all don't have. And I am willing to allocate some shares to this person. Does that mean that I would now need to sit down with you guys for us to all re-agree a shareholders agreement because we're about to graft somebody in? Or is there a separate agreement between me, the business owner, and this new person?
Yeah. So if he's coming in director, you want to propose him as a possible new shareholder to the company.
Yes.
That is the company overall. It's not something that's personal between you and him. So that's the first thing. And actually, this could be where the shareholders agreement's helpful because it might be that you and your fellow shareholders have decided, well, actually, if we want to appoint a new director and we want to give him shares, those are the types of decisions that we want to reserve to ourselves. So you can reserve decision makings to all of the shareholders. That's something which is quite possible. Yeah. And you would bring them in. Now the advantage actually in that scenario is that if this director wants to become a shareholder, the chances are that they'll be very keen to sign the shareholders agreement as well. So that there would be a situation whereby, they would get a copy of the shareholders agreement and look at that. But the intent of moving forward positively, the likelihood is that actually if you've got a very sensible shareholders agreement that they would agree to it as well.
Yeah. So I wouldn't need to do a new one. It would just literally be the same one but revised.
Revised to incorporate.
Yeah. Okay. Yeah. No, that's good to know. So the next question is, I think we've kind of already answered this, but just to probably get a more specific answer, how does someone break out of a shareholders agreement?
So again, that's looking at the exit provisions in the shareholders agreement and finding a way forward. We covered that slightly, but actually there's another scenario which may arise, particularly if you're going into a business with a view to selling it at the end of the day. So say, for example, going back to us setting up together in business, majority shareholders, and we've brought in a director with a minority shareholding, sort of less than 25%. And we're in this situation whereby we have found a buyer for the business. So we want to leave, we want to sell the company, but we've got other shareholders who are actually reluctant. They maybe want to stay in the business, concerned about what their employment might look like if the business is sold, so are reluctant. Now, in a shareholders agreement, you can incorporate what's called a drag clause. And a drag clause is when the majority shareholders decide they want to sell and they can pull along minority shareholders with them. So in actual fact, the person buying the company, rather than just purchasing the major shareholding, will buy all of the shares. And most people who are buying a company don't want to buy just part of it. They want to buy all of it. But if you're in a situation whereby you founded a company, have a majority shareholding, but you're prevented from selling by somebody who's got a lower shareholding, that can be really frustrating.
Yeah.
So having that shareholding agreement in place to cover that sort of scenario when you want to exit can be really important.
Yeah. How many people, what's the maximum, in your eyes, how many people minimum should be in a shareholders agreement and how many people maximum should be in a shareholders agreement? Because there's a reason why I'm saying this, because when there's a lot of people at the table, the saying goes that when there's too many chefs or too many cooks in the kitchen, like the final product's not always the best, for example, or it takes things longer to do. How many people, from your experience, do you recommend to maybe be in an agreement?
Okay, so shareholding, first of all, 2 people minimum.
Yeah.
So that's it, and that's if you're setting up in business, 2 of you there, very clear on what you want from the company. You start out with that. As far as a maximum is concerned, you're then looking at how a company is governed overall. So you will likely have a board of directors, and not all of the directors are likely to be shareholders. And a lot of the decisions may be made by the board of directors and not the shareholders, depending upon what the shareholders have actually reserved for themselves to decide. So I think as the company grows, actually there becomes a little bit more of a distinction between the board of directors and the decision that's made on a day-to-day basis, and actually the ownership, the shareholding. So there isn't a maximum number of shareholders, but you're absolutely right. You don't want too many people involved, so it becomes cumbersome.
Yeah.
So two things. First thing, from a shareholding point of view, there should always be somebody who has a casting vote or a way to break that deadlock if that were to occur. And also some sort of mechanism to really deal with disputes as well. And then from the business point of view, from the operational side, you want to also look at how the decisions are made in that context. So there gradually becomes a distinction between, say, a management team or the directors, board of directors, and the owners of the business. And that becomes clearer as the business grows.
You mentioned that about casting votes and there being a clear, distinctive way to see what happens on this side or on that side. Does that mean potentially having 3 there? For example, if there's only 2, you agree one thing, I agree one thing, how are we going to resolve it? Does that mean that in that scenario we bring someone on board? How do we deal with that scenario?
Yeah, good question. And when people set out in business, that can often be a problem. You know, we spoke about when we looked at the different scenarios, if, for example, I suddenly went, well, actually, I think we should expand to America, and you're going, no, we need to crack the UK market first.
Yeah.
And we've got to this sort of standoff, or what it's called deadlock position. There are a number of different ways of dealing with that scenario in a shareholders agreement. The first could be, we could get a non-exec director, and between us, and we could go, well, actually, Richard, we both trust his business judgment.
Yeah.
He's someone who knows we know would have our best interests at heart. We could have him as a non-exec director, and both, if we come to this point where we can't decide, agree to defer to him and his decision making. We could again ask somebody to join us in a shareholding, but without an have shares, but without ownership rights, without a dividend entitlement, but to have a casting vote. So again, if we were in a situation where we couldn't make that sort of decision, that they could. So that there are scenarios and different mechanisms like that that you can utilise.
Yeah. I'm really happy I asked that question, because I know that quite a few people, when they do start off in business, especially small business owners or people, micro business owners, there's literally one or two of them. So they might find themselves in that scenario, and what you've just advised there or shared on is something that they could take on board. So I think that's really useful for people to apply. I can tick that question off. What scenarios have you seen where shareholders agreements have worked well?
I guess drawing on my background from a dispute point of view, I've seen shareholders agreements work well when parties are in dispute. And the reason for that is when you're in dispute with someone, the chances are you won't agree on much at all. And that can include how you deal with the dispute as well as the problem that's triggered the issue in the first place. So actually having an agreement that sets out what happens, do you go to mediation? Do you look at arbitration? Do you do something completely different? All of that actually at least gives a way forward and guidance and a clear pathway as to how you resolve a dispute.
Yeah.
So that is a great thing. And also if you want to value the shares as well, having a mechanism in there for the way the shares should be valued or could be valued is also helpful for people if they need to go down that route.
Yeah. So now switching that question to the other side, what scenarios have you seen where a shareholders agreement didn't work well?
Didn't work well was when not all the shareholders were party to it. So then you've got rules for one and then different ones that would apply to another. So in that kind of scenario, that wouldn't work as well.
Yeah. So that's going back to the scenario that I painted before. Shareholder, but the person coming on board. Could you explain your answer based on that scenario?
Yeah. So in that situation, you want everybody to be party to the shareholders agreement and everything it encompasses, because if they're not party to it and they were to leave the business, they could take their shares with them. They could sell them to somebody else, they could pass them on to somebody else, or they may not engage with the company if there's decisions to be made. Yeah. And it becomes harder then. But actually, while somebody is engaged in the business, is wanting its best interests, that they're really core to them, then actually they'll want to be party to a shareholders agreement as well with you, because it offers them as much protection as anybody else. Yeah. So it's a helpful thing, to have in place. Yeah. And I think coming back onto the looking at the disadvantage of having a shareholders agreement, the other point would be is if your shareholders agreement doesn't sit well with your articles of association. So in a time like that, everybody might have invested a lot in putting together a shareholders agreement and feel, great, this really sets out how our relationship works together, how the company is going to be managed. Yeah. But in actual fact, if it contradicts what's in the Articles of Association, then it's the Articles of Association that come first. So if there were a problem, those would have an overriding interest over the shareholders agreement. So that wouldn't be a great situation, and that's why you want to make sure that they're aligned. Yeah, that's really comprehensive, very, very comprehensive. So from what I've gathered, having a shareholders agreement is, to me particularly, it's a bit of a no-brainer, to be honest, because it just gets you out of tricky situations. Yes. It allows you to navigate through scenarios, like we just use the Richie Rich analogy there. Mm-hmm. If anything was to happen to the majority shareholder, what then happens to the business, who is running the business, different things like that. Mm. It's definitely, to me, a bit of a no-brainer. Thank you so these are my questions. I'm just gonna ask if there are any questions from watchers or listeners. Not as of yet.
From your background, what else could you potentially say people need to be aware of when they are setting up their business? Not just when it comes to shareholders agreements, but what other things should they consider?
I think for me, it's a shared vision, and when you set out in business, you might have an idea of what service you want to sell, what product you want to sell. So that's often quite key. But actually, I think now the purpose of the business, what the vision is, what the goals are, and underpinning that with a really clear strategy is really important.
Yeah.
You know, I think having your strong marketing strategy, understanding and taking measurements of where you're going as a business, reflecting on that, taking advice. I know you've had sessions on mentors as well.
Yes.
And I think that's really important. You know, we look at all professional athletes, and they have coaches.
That is true.
And in order to get their peak performance, they have help. You know, it's taken quite a while for the business professionals to kind of go, yeah, actually, in business, you need people there alongside you too. And so I think it's all of that. You know, don't be afraid to ask for support. Get involved in a community like this, and see what help there is out there. Get ideas, get talking to people, but have a very clear vision on where you want to go and support that. Your strategy is not your vision. They work alongside each other, but you use your strategy to progress.
Yeah. If anybody wanted to get in touch with you after this conversation, what's the best way for them to reach out to you?
So you can reach out to me through my website, which is www.sarahcanning.co.uk. I'm also on Twitter, which is Sarah J. Canning, LinkedIn, and also on Instagram as well, which is the Dispute Resolution Specialist.
Yeah. So we're gonna have all that going out in our comms after this conversation. But if we have any questions or anything like that, so it's been amazing having you here this morning.
Thank you.
Very, very comprehensive. I'm definitely going to go back and listen to this myself because there was a lot of gems and a lot of nuggets there. So thank you very much for your time this morning, Sarah.
That's a pleasure.
Really, really appreciate it. Any final remarks from you at all?
Shareholders agreements are really important. As a business owner, you invest your heart, your soul, your time, your energy into your company, and it's worth so much. But look after it. And if you actually really, really want to grow in business, then you've got to get the basics and the fundamentals right to protect all of that investment. And that investment's not just financial, it's the personal investment as well. So getting a shareholders agreement is really important financially, personally. It protects everyone around you, but it gives you a really strong foundation to move forward.
That's really good. That's really, really good to hear. So you heard it here first. The agreement is really, really important to not just financially, but personally. And I can imagine also mental-wise as well, because like I could just imagine the back and forth disputes can cause business owners, because obviously they want to have their attention on running the business. But if they're going through any potential disputes, having the agreement there with clear guidelines on how disputes are dealt with. I remember there's Richard used to do something called Aussie's Nuggets, which he still does. We need to get him back on the couch, where he actually spoke about scenarios where having a clear plan of how to deal with disputes is very, very handy, because you don't want to ever come to a point where you're throwing blows. This is not Grant Mitchell.
No.
This is not Phil Mitchell.
No.
This you can deal with things amicably.
Yeah.
So having bullet points, having something down of how, if we ever entered into this scenario, how do we deal with it? I think that the agreement is something that is definitely something useful, particularly for that.
Absolutely, because disputes are distracting. You know, it takes you away from the core business, which is always future focused.
Yeah.
You know, where's the next sale coming from? what market do you want to target? How are things running? And actually, if you're dealing with a dispute, you're looking backwards. It's what's happened in the past.
Yeah.
So you don't want to be doing that. You want to be future focused. So you're right. Having that mechanism gives you an assurance that there's a way out.
Yeah, yeah. Thank you. I was about to round up, but then I started speaking again. Thank you so much for your time this morning, Sarah. And thank you for joining us today. If you would like to know more about Sarah and how you get in contact with her, there'll be further details after this webinar that will be shared on our socials. Do tune in to two of our podcasts. The first podcast, the Drive podcast, hosted by Richard Osborne, where he speaks to founders, senior execs about what really drives them in business. Now, these are people that have been there, they've done that, and they've got the battle scars to show it. So these are people worth listening to. And our second podcast, the Grow podcast, which is all about what you need to do and to learn to grow in business. Follow me on my journey as I speak to experts such as Sarah, such as people in marketing, sales, finance, how to get investments. These are all different topics that we'll be covering on the Grow podcast. So thank you once again for joining us this morning. Have an excellent day.